Hey out there, legal warriors. In this video, I'm going to cover 5 reasons a prosecutor might choose to decline to file criminal charges against a suspect. And that's very important to know what those 5 most common reasons are, so you, your loved one, your attorney can predict what's likely to happen. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. What do I mean by declining to file charges? Well, in certain types of cases, the prosecutor is the one who makes a decision, either after an arrest or after an investigation by the police, about whether or not the prosecuting attorney's office will file an actual criminal charge and therefore prosecute the suspect. And this happens in every felony case, because if you've listened to other videos, in Washington State, police officers can arrest for investigation of felonies but cannot charge a felony. Similarly, for certain broad levels of jurisdiction, officers like Washington State Patrol and most sheriffs, they also have to go through a prosecutor decision process besides directly filing the charge themselves. Just because someone's arrested doesn't mean they're charged. The other situation where it happens is an investigation by a police officer. There is no arrest. There's an investigation after the fact. It could be as simple as hit and run or theft or sex offenses, all types of things. And a case is referred to the prosecutor for them to make a decision. And this would also apply if a case was referred to juvenile court. So the 5 main reasons why a prosecutor might decline to file a charge, which means the defendant not getting charged or the suspect never being a defendant, I'm going to cover those now. So number 1 would be simply a lack of evidence. And when I say lack of evidence, I mean to meet the standard under the statutes to prove a case beyond a reasonable doubt. If somebody gets pulled over for a DUI and they blow .03, which is not above .08, well, then the prosecutor's going to look at the police report and make a determination. Is there enough other evidence that they could still prove this person guilty of DUI by showing their ability to drive is affected by alcohol? Because that's the under the influence prong of DUI. In that case, the evidence can't get any better than what's already in the report, right? The investigation is already done. We can't go back in time and redo it. We can't go back in time and get a blood draw if we didn't get one. So sometimes a prosecutor will decline simply based upon lack of evidence to meet the statutory elements. And I'm talking something different than a witness problem, different than what someone might testify to problem. They've got their witness, they've got their police officer, they've got a certain fact pattern, but whatever is in the fact pattern isn't strong enough where the prosecutor can meet their case. And not many cases fall into that category because prosecutors can sometimes gain evidence or improve evidence, but that is an important category where a prosecutor will look at it and go, this just isn't enough to prove a crime. In that case, they enter a decline, and then the defendant will never get charged with a crime. Moving on to reason 2, this is a different type of reason that sort of leads into evidence, but isn't really evidence. It's the prosecution relies on non-police officer witnesses, lay witnesses, and the prosecutor can't find the witnesses, right? There's no response when the prosecutor reaches out to the witnesses to see if they're available to testify. Now, some prosecutors will just see a police report and go ahead and file a case without talking to witnesses, and in less serious cases, non-felonies, that's what we would expect. The volume of cases is too large, and the stakes aren't quite so large in the prosecutor's eyes. They're going to assume that their witnesses are available and go ahead and charge a case if it looks like those witness statements are sufficient to support a charge. But at the felony level, many prosecutors' offices are not going to file a charge unless they know their witnesses are available and are cooperating and will testify to support whatever they said to the police during the investigation that's leading to the prosecution of the suspect. A felony is such a big deal, most prosecutors' offices are not going to make an assumption that the witnesses are available and go through all this trouble because there's a limited amount of cases they can file just due to staffing, go to all this trouble if they don't think they have their witnesses on board. So if you are a witness or an alleged victim and you're not wanting the suspect prosecuted, obviously, if the prosecutor can't find somebody, it's going to be harder for them to prosecute. So just keep that in mind when we're thinking of reasons why a prosecutor would decline to file a charge. The third reason a prosecutor might decline to file a charge is related to reason number 2. It's not can't find the witness, it's uncooperative witness. They know how to find the witness, but the witness is now either going to testify to something different than what the police officer investigated, or the witness is simply telling the prosecutor, I'm not going to show up no matter what you do. And then it's sort of a game of chicken. If the prosecutor can find the witness, and the witness is basically telling the prosecutor to take a hike, I'm going to change my testimony, I'm not going to show up. Depending on the character of the prosecutor, they could do things to force that witness in. They could threaten the witness with perjury, although it doesn't normally happen in Washington State, it could. They could ask for a material witness warrant to try to get the witness arrested and bring them to a trial. So it's a little bit more of a dangerous game, both for the prosecutor and for the uncooperative witness in deciding how this is going to go down. So it's a little bit less powerful reason to decline than the last one, because in this case, the prosecutor does have some options if the witness is just simply uncooperative. On a misdemeanor level, it's more likely probably not to file a charge. I think on a felony level, they're probably more likely to use the power they have because a felony charge is a bigger deal than a non-felony charge in the eyes of the law. And therefore, prosecutors in general are more willing to take some risks and use their power and make some threats to try to do the right thing in their mind and getting the witness to testify to whatever they told the police officer. Of course, they're making an assumption that that witness was telling the truth to begin with, which is why, as a defense attorney, it can get pretty annoying dealing with a system that always thinks the first statement was true and the second statement is false. That isn't always how it is. So moving on to the fourth reason a prosecutor may choose to decline a case is by the time they get around to it, it's simply too old, right? The case is old. Now, that can contribute to number 2 and 3, a witness they can't find or an uncooperative witness. But really, if the case is too old, it's a whole nother thing. Is it so important now that we prosecute this 2 years after the fact? Let's say it's a domestic violence assault 4th degree. Let's say it doesn't look too bad in the report. It's sort of a push. It's not the most serious-looking report as far as the prosecutor is concerned. And 2 years have passed. Well, they might take a look at the record of the suspect and see there's been no problems in 2 years. And they might find out that the suspect and the alleged victim have been living together the whole time with no problems. And they may make a determination that, hey, I'm going to have to explain why it took so long, right? They may determine that explaining why it took so long in such a de minimis and old case with no new problems, maybe it's not worth filing. And I'll say when I was a prosecutor, which I was for 7 years, we had a very small staff. And I will admit that a few times I would get to reports that had been in our charging decision stack for way longer than they probably should have been. In those cases, I personally did take into account how old the case was in making a decision about whether or not I was going to charge it. And if the case was older, I was less likely to charge it because there'd been no other problems. It seemed less urgent in a situation where there was limited resources. Why it was taking so long to get to charging decisions is staffing in prosecutors' offices often they don't measure up or keep up with the level of referrals to the office, right? Court staff increases, police force increases. The last group in law enforcement, in my opinion, to see an increase in staff is the attorneys, right? The attorneys, the prosecutors can control their caseload to a degree by what they charge, what they deal, stuff like that. So if the case is older, it's more likely that it may not get charged. And finally, number 5, it's related to number 4, but it is different. It's the prosecutor simply too busy. There is only so much emotional and physical energy we have as people, and this includes prosecuting attorneys. If the prosecutor is very, very busy, then they may need to find a way to decline charges that are less serious, that they just simply don't have the staff for. So it's different than too old. It could be a really new case, but your attorney may know that, hey, a certain type of case isn't going to be charged in a certain jurisdiction because the prosecutor's office is making a decision that they're too busy. This applies to certain types of phishing cases. For example, Snohomish County has standards that encourage declining certain types of phishing cases just from a prosecutorial resource point of view. It can also apply to things like suspended license charges. They might be less likely to file that if they see somebody has already got their license back. So when a prosecutor is too busy, they have to make some choices about what to charge or not so they don't break the system and they don't break themselves. And this varies jurisdiction to jurisdiction, but a prosecutor who is too busy is going to find a way to decline more cases than a prosecutor who doesn't have many cases at all and they're looking for something to do. So your smaller jurisdictions, let's assume that they may have less cases per prosecutor. Those smaller jurisdictions may be more likely to charge than a really busy jurisdiction that simply doesn't have enough prosecutors. So those are 5 reasons why a prosecutor might decline to file a charge. I know a little something about it because I was a prosecutor for 7 years, and a little something about it because I've been making those predictions and trying to influence outcomes for 20 plus years with our law firm, which is located in Linwood. So if you find this useful, please like and please subscribe. More people get to see it. More importantly, if you have a legal problem and you need some help, feel free to reach out to my firm. If we get on board, we'll identify what happened, we'll find a way forward, and we will be there for you. Thank you.